Thank you so much. Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Mr. Secretary, would you please call the roll?
Assemblywoman Bilbrey Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner. Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Nguyen.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong. Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. We do have a quorum. For the time being, let's mark Assemblywoman Summers Armstrong absent excused. I expect her to be here shortly. Let's mark Assemblywoman Krasner absent for the time being. I do know we have members who are going to be presenting bills in other committees this morning. It is getting to be that time of the session, but I think those committees don't start until 9 o'clock. So hopefully folks will be able to jump on here soon. Good morning again to committee members. Good morning to those in the public who might be watching on our YouTube channel. Welcome to day 30 of the 81st session of the Nevada Legislature. And if you're keeping tally at home, that means we are 25% of the way through this session already, which is quite stunning, to be honest. It seems like it's gone very quickly. Before we get started on our agenda today, just a few housekeeping rules. Members on the Zoom and guests who may be on the Zoom with us, please make sure to mute when you're not speaking. That'll help with the audio feedback. For presenters, if you could remember to state your name every time before you speak, and especially if somebody asks you a question, if you could remember to state your name before you answer, that will be helpful. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That is perfectly okay, but we need to make sure we're being respectful of one another, of the legislative institution, and most importantly, of our staff and broadcast services who is helping to make these meetings happen every morning. And then finally, many members will be using multiple devices to participate in the Zoom and to access exhibits and the like. So please don't see it as a sign of disrespect or inattention if members are looking away during the committee hearing. We're just trying to navigate this new Zoom world. So with that behind us, let's go to our agenda. And I'm still trying to decide how we're going to take these bills. So let me see here. And let me ask Assemblywoman Cohen, do we have your other presenter on or not?
No, Chair. BPS is still working on the technical difficulties with him. So if you'd like to move forward with the other bill, that would be fine with me. Thank you.
Great. Thank you, Assemblywoman Cohen. So then what we're going to do, we have the luxury of having two bills on the agenda today, so we can pivot, and we're going to go ahead and hear the bills in reverse order that they appear on the agenda. So at this time, I will open up the hearing on Assembly Bill 160. Assembly Bill 160 revises provisions governing credit awarded to reduce a sentence of imprisonment. I will let members know, in case you didn't have a chance to see, that there is an amendment up on Nellis that has been provided by the sponsor of the bill. I also believe there's a proposed amendment provided by somebody in opposition to the bill. So we'll have an opportunity to review both of those. And I want to welcome back to the Assembly Judiciary Committee, Assemblywoman Torres, who served on this committee last session. Assemblywoman, it's nice to have you back in the committee. And I believe, if I'm not mistaken, that Vice Chair Nguyen might be assisting in the presentation of the bill. So we'll give you a chance to go through Assembly Bill 160, the proposed amendment, and then I'm sure we'll have questions. So please proceed when you're ready.
Thank you, Chair, and good morning to the Assembly Judiciary Committee. Okay, my screen froze. Am I still good? Just a thumbs up. Okay, perfect. Thank you. It is always a pleasure to be back in the Judiciary Committee this fine morning. Thank you, Chair Yeager and committee members. I am Selena Torres, representing Assembly District 3 for the record. Today, I'm here to present Assembly Bill 160, which revises provisions governing credit awarded to reduce a sentence of imprisonment. So first, I'm going to start with some background information, then I'm going to do a quick breakdown of the bill. During the second week of session, a former student called me as he prepared for his sentencing hearing the next day. For the last year, his sentencing date had been regularly pushed back because of COVID-19 and safety measures. And through it all, he's been on residential confinement. He had been in residential confinement for nearly 13 months. He also mentioned that he would not be getting any credit for the time he served on residential confinement. It was a very challenging conversation, to say the least. He did exactly what we want people to do. He moved to a different side of town where the violence had started. He started working, and he recognized that he needed to get on the right path. And he started making those life changes. That is exactly what we want of individuals that are serving time in any location. Residential confinement is also known as house arrest. It is punishment. It is punishment that defendants undergo while they are awaiting trial. Their movements are restricted and electronically monitored. The only reason they can leave their house is sometimes to go to work, to go to court, to meet with their lawyer, or to go to a doctor's appointment. If a person is in a county jail or prison awaiting trial, the court can allow credit for the time spent to reduce the person's sentence. However, if a person is subject to house arrest while awaiting trial, credit is generally never given. People are given credit for time served on house arrest after their conviction, but not before their conviction. This bill is important because house arrest is a punishment. People like my former student who have spent a prolonged time on house arrest and abided by the rules of the court should be allowed credit toward their sentence. As we have this conversation, it is important to note the physical impact that this has on the hardworking Nevada families. To incarcerate someone, it costs Nevadans $150 a day. This comes at a cost for our community. Next, I'm going to go ahead and go through the sections of the bill. And just a reminder for the committee members, I will be working off of the mock-up that you should all have a copy of and is posted on Nellis as well today. I did submit an amendment on this bill, and it is based off of my conversations with different parties and stakeholders in this bill. Section 1 would require, rather than authorize, credit for time spent in confinement before conviction. And it also gives the court the discretion to allow credit for time spent in residential confinement before conviction to reduce a sentence. So it's kind of a cleanup language, if anything. I understand that there is another proposed amendment, and I've been working with our stakeholders so that we can kind of find some middle ground. The conversation right now has been whether or not misdemeanors should be off of the table completely, or whether there should be some type of partial credit for misdemeanors. The reason being, of course, that with a misdemeanor, it must be recognized that their sentencing time might be less. And so I've been working with the stakeholders, and I really do appreciate the time that they have spent meeting with me so that we can kind of find some middle ground. I'm not sure if Vice Chair Wynn would like to add any additional remarks, or if not, we can go to questioning.
Just briefly, one of the cleanup language in the amendment that was submitted by Assemblywoman Torres just kind of cleans up some language. I think everyone generally understood that you should get credit if you are in jail. So if you are awaiting your trial or you are awaiting your sentencing and you were physically in a jail, you should get credit for time for that jail time. And unfortunately, our language in our statute said may. There has been case law, and I know that this is getting very technical, that has already cleaned that up. So this is already some cleanup language that just makes our statute consistent with what the case law is. That says that if you are incarcerated and you are physically in a jail, you do get credit for that time towards your actual sentence. The other section of that proposed language authorizes judges and gives them authority to take into consideration whether or not people are doing the right thing when they are on house arrest or residential confinement, and allows them the authority that they may give credit towards that time if they are incarcerated or if they are on house arrest or residential confinement. So that some of that is cleanup language just to make it consistent with common sense and the case law out there. but it also authorizes judges to, reward with credit, with the punishment and the good, accountability that people have done to allow them credit. And I will, confirm what Assemblywoman Torres said about misdemeanors. It is unique because, especially now, it's like more relevant during a pandemic. If someone was to be placed on house arrest, the maximum penalty for a misdemeanor is 6 months in custody. And if you served 6 months waiting for your trial on house arrest, your sentence would be accomplished just by the house arrest nature of house arrest. So we are continuing to have like ongoing conversations with them. This is a bill that was brought during the 2019 session, and I believe it passed out of this committee unanimously with that amendment with the misdemeanors. So we did have this conversation pretty extensively last session for the returning members, and for the new members, if you would like to go back and see some of that testimony from 2019, I believe it's available on Nellis as well. And with that, Assemblywoman Torres, do you have any further comments on it?
No, just the bill number from last session was AB 109 of the 2019 session, in case there's anybody that does want to go through and reread those minutes.
Great. Thank you to the both of you for presenting, and thank you for highlighting the bill from last session. As indicated, that bill did pass out of the Assembly Judiciary Committee. It did get a vote on the Assembly floor, and I believe it was unanimously supported on the Assembly floor. It did not, however, make it out of the Senate Judiciary Committee, I believe. So that was the fate of the bill last session, and we're back again this session with the same concept. So with that behind us in the presentation, are there questions that any members have? Actually, before I get to questions, let me note for the record that Assemblywoman Summers Armstrong has joined us. So, Mr. Secretary, if you could note that in the minutes that she is present. I don't think Assemblywoman Krasner is here yet, so please continue to remark her as absent. Are there questions for Assemblywoman Torres or Vice Chair Wynn from committee members? Assemblyman Wheeler, please go ahead.
Thank you, Mr. Chair. I'm just wondering, I like the concept of the bill, but I'm just wondering, as we get into more discussions on cashless bail, which I'm sure are going to come in this session, how is this going to affect that as far as, someone gets arrested for something and they're detained until trial, they can't make their bail, et cetera, so they're put on house arrest until trial. If it's a cashless bail thing, would that actually reduce the time? Would that, I'm trying to figure out how it all fits together. Maybe I'm not even asking the question right.
That's okay. I think Assemblywoman Torres, I think I can answer this. So the way that it currently works in most of our jurisdictions is, let's say, a crime occurs, it's investigated, a suspect is arrested for that particular crime, and they are brought to the detention center. Like in Clark County, for example, you see a hearing master or you see a justice court judge almost immediately, usually within 48 hours, to address your custody status. And in fact, recently, most of these courts have like lots of options now for pretrial release. It's similar to, there's cash bail is an option. House arrest is an option. And even house arrest the programs are pretty extensive. Like if you're on house arrest, not only are you confined to your home unless you are having a legitimate job, you can't have a job that you are doing under the table or anything like that, because you have to provide your work hours, you have to provide all that kind of verification. They also have random drug and alcohol testing. Sometimes there are conditions of release that include no alcohol, no random drug and alcohol testing, or other types of treatment. So they're pretty extensive. And so that is what happens. So a lot of times people may be released with no bail, no cash bail, but they do have these other conditions like house arrest. Does that make sense? Does that answer some of your questions, Assemblyman Wheeler?
Yeah, it does. Thank you very much.
Okay, do we have other questions from committee members? Oh, I see a few, so let's go. We'll go Assemblywoman Hanson, Assemblyman Orenlicker, and then Assemblywoman Cohen. Please go ahead, Assemblywoman Hanson.
There we go. Good morning. Actually, more of a comment. Was here for the last session when we went through this bill. And I think it's interesting, if we're revisiting this bill now, it might be in your favor that we're doing it post-pandemic. Well, not really post-pandemic, but in a pandemic, because I think all of us understand now a little bit about house arrest, having to have our activities curtailed over the last 11 months or so. So anyway, that might work in your favor, and glad to revisit this bill again and appreciate the work you're doing. Hope you can work things out in the amending process.
Thank you, Assemblywoman Hanson. We'll go next to Assemblyman Ornlicker.
Thank you, Mr. Chair. And my question's about Section 2. I like this bill a lot, and as I read Section 2, it sounds like it might not apply to your former student, and just curious about your thinking about not making it retroactive.
Yeah, this legislation is not going to apply to my former student, and this is pretty common for it to take place after the fact. I think that if we were to put it retroactive, it would probably come with a fiscal note, as those individuals would have to be resentenced. And so that would make it very costly for the state of Nevada. Obviously, I believe that, this is going to be excellent for individuals that have not yet been sentenced by October 1st of this year. Unfortunately, I don't feel comfortable putting a fiscal note on this piece of legislation at this time.
Let's go next to Assemblywoman Cohen.
Thank you, Chair, and thank you for bringing the bill back, Assemblywoman Torres. So I don't think you covered this, but I was dealing with getting some things settled for my hearing. So I'm sorry if you did, but on the May, with the court having discretion, is the court going to have pre-trial, like parole and probation pre-trial reports or anything like that they can go off of? Or what's the court going to have as part of their, make their determination?
I can go ahead and answer that, Assemblywoman Torres, if that's okay. Currently, what happens with places that utilize and have house arrest programs is if you are successful, you get a report, and a report goes to typically the court, so the judge, and also goes to potentially the defense counsel as well as the prosecutor to let you know if you've had any violations of your house arrest. If you do have violations of your house arrest, for example, this happens, someone tests positive for drugs or alcohol, and all of a sudden they are brought back in, a report will be produced and will say, defendant X was on pretrial house arrest incarceration. They tested positive for, alcohol or marijuana or illegal drugs or whatever it is on this date, and they will be brought back into custody. So that's typically how it works. And so you're able to know how long someone is on house arrest in that report. And so I imagine that it would be very seamless for the court to be provided with information on pre-trial, like residential confinement.
Thank you.
Do we have further questions from committee members? If you could raise your hand. Assemblywoman Hanson, do you have a question this time or another comment? Go ahead.
Actually, it just takes a while for my brain to finally kick in with the questioning side of things. Do we have any stats to show some of the, we sometimes worry about recidivism when people have been actually physically incarcerated, but do we have any statistics to show us, or even updated ones, how this works in helping people stay with their jobs, provide for their families, some of the positive aspects besides maybe the financial and some other things for the state?
I will tell you, I don't know offhand, but I do recall last session when Assemblyman Fumo was presenting the bill. I remember there being some testimony in that area. I don't know if Assemblywoman Torres has anything, but I'm sure that there is plenty of information out there that can talk about it. I think your instincts are right on. If someone is on residential confinement, I think they have that punitive aspect where they have a physical reminder to stay out of trouble and to stay at home. And if they are fortunate enough to like be able to maintain their job, you know, obviously, I think that's what we want to encourage is like that, you know, good behavior.
Yeah, and I don't recall quite, I'm trying to skim through the minutes from the last session pretty quickly. But I can definitely get back to you with an answer. I'm not sure if our policy analyst has any information on that. Or our testimony might actually help answer that as well.
And that's fine. We can continue at the meeting, but maybe if it's something we could get offline later, that would be, maybe we could get it from former Assemblyman FOMO, or maybe there's just some updated information that we might hear about in testimony. So thank you so much.
Do we have other questions from committee members? Assemblyman O'Neill?
Thank you, Chair. Just quickly, I may have missed it. Can you explain to me what's the conflict between your amendment and what Henderson is proposing, please?
Yes, definitely, Assemblyman. Thank you for the question. So the difference in the amendment is that the Henderson amendment changes so that misdemeanor would not get credit for time served on house arrest. At this time, you know, we're still working with Henderson and some of our different key stakeholders and to continue to have a conversation about whether or not this should be applicable to misdemeanors or if it should also be applicable to like a partial credit or something like that. So we're continuing to have this dialogue, and I'm definitely open to the ideas of this committee as well.
And it's just in misdemeanors, correct, that they're having the conflict with you? And it's only Henderson?
Henderson is the only municipality that brought forth the amendment to me, but we had a conversation with several of our stakeholders yesterday. And the conversation really, just to kind of reiterate some of the discussion from earlier, is that, you know, a misdemeanor might have a sentence of 120 days. And so if you have a sentence of 120 days, that would be your entire sentence, so that you would not, there would essentially your credit, your time served would have been the house arrest. And we understand that there is a difference between confinement or incarceration and residential confinement. And so the dialogue continues to be whether or not there should be perhaps for misdemeanors some type of partial credit for the time served. So, and so we're continuing to work with Henderson and our other municipalities to continue this dialogue.
And just to follow up with that, Assemblyman O'Neill, for example, with a misdemeanor, the maximum penalty is 180 days in custody. And if you were to be set for trial twice and have 2 continuances, that would put you at 180 days. And so we want to encourage people to get like treatment. We want to encourage people to do counseling if that's necessary. We want to encourage like other aspects of like rehabilitation and retraining and counseling and therapy. And under a misdemeanor model, if you give like full day-to-day credit, you might like not be able to capture some of that like therapy and help that you would want because the sentence is so short.
If I may, Chair, maybe I've been out of the court system too long, but aren't most misdemeanors that give them house arrest anyway so they can keep their jobs?
Unfortunately, the opposite is completely, in my experience, and you know, I work in the municipal court on a daily basis, so I can tell you that we don't have that system, and in fact, most of the municipal courts don't utilize house arrest as regularly as our felony and justice courts.
Thank you for that clarification. Thank you, Chair.
You're welcome. Do we have further questions from the committee? Okay, before we go to testimony, I want to tell you that I again was fact-checked. This happens a lot. So Assembly Bill 109 from the 2019 session, which was the bill last session, technically it did not pass the Assembly unanimously. Assemblyman Hambrick was absent excused. So it was 41 votes in favor, 1 absent excused. So technically that is not unanimous, although it is unanimous of those present and voting. So just so our minutes are clear, Okay, final call for questions on this bill.
I called Mr. Hambrick, Mr. Chairman, and he said he would have voted for it, so I think you're okay.
Thank you, Assemblyman. I'm sure he would have as well. So, okay, so I don't see any further questions. Presenters, Assemblywoman Torres, Vice Chair Nguyen, thank you for presenting. I'll have you sit tight for a minute while we take some testimony, and then I'll give you a chance to do concluding remarks. I'll now open it up for testimony in support of Assembly Bill 160. I don't believe we have anyone on the Zoom with us in support. BPS, could we go to the phone lines to see if we have folks in support there? I'm under the belief that we may have a few of them. And if that's the case, could we please ask the first caller to provide testimony?
Thank you, Chair. To testify in support of Bill AB 160, press star 9 now to take your place in the queue. Would the caller with the last 3 digits of 212 slowly state and then spell your name for the record? You will have 2 minutes and begin.
Good morning. My name is Sarah Hawkins, S-A-R-A-H, last name H-A-W-K-I-N-S. I am here testifying in support of the unamended version of AB 160. I'm speaking on behalf of Nevada Attorneys for Criminal Justice. Thank you for the opportunity to give this testimony this morning. The crux of my testimony is that confinement, no matter what that looks like, no matter where it takes place, is a restriction on liberty, and those who are subject to that confinement should get credit for those days in which they were confined. I think this makes perfect sense in light of the Nevada Supreme Court's recent Valdez-Jimenez decision, which makes clear that a pretrial condition, any pretrial condition while you are innocent pending trial, is a liberty restriction. Residential confinement is a liberty restriction. One of the other examples I can point to is that there are different levels of custody inside a jail. You have maximum security, you have close security, you have medium security, you have lower security inmates. Each and every one of those folks receives credit for their confinement. Just because confinement happens outside of the jail, it doesn't mean you don't have an officer telling you what to do, where you can go, how you can do it, and who you can see. Because of those limitations, we are in support of AB 160, which would give those who are subject to confinement the time that they are entitled to. Thank you.
Thank you for your testimony and support, Ms. Hawkins. BPS, could we take the next caller, please?
Would the caller with the last 3 digits of 209 please slowly state and spell your name for the record, and you will have 2 minutes and may begin. Once again, with the caller with the last 3 digits of 209, slowly state and spell your name. You will have 2 minutes and you may begin.
My name is Ashley, A-S-H-L-E-Y, White, W-H-I-T-E. Hello, my name is Ashley. I'm here today reading a letter from a person who is personally impacted by AB 160 and home confinement. She asked me to read it on her behalf. It's very hard to understand that being on home confinement is not much different than actually being incarcerated, but from personal experience, it's not. When you are in jail, you'll take any way out, desperate to be out. But being on house arrest is very difficult for anyone. That includes your family. I'm currently on home confinement. I'm living with my elderly parents. They are on a fixed income. They pay for my personal expenses. They buy my food. They have to run all my errands. During this pandemic, this is especially difficult. They have their own rent and bills to pay. I'm very lucky to have them. Lots of people don't have that luxury. I don't get to go to any religious services. I've missed birthdays. I've missed events and everything. I get to watch everyone leave and hear my kids and family wish I was there, just like they did when I was in jail. It's very disheartening to me to know that this time is a waste for me when it comes to my time. This is a waste. All this time I'm missing with my family, and I still can miss even more when it comes to the resolution of my pending charges. charges that I haven't been found guilty of, charges that I may never do time on. I didn't kill someone. I don't even need jail or prison. I need treatment for my struggle with drugs. I am in support of unamended AB 160 because time served should be time served, and we should get credit regardless of where we serve it. This isn't freedom, and the loss of it is my punishment if or when I am convicted. In a country that says we are innocent until proven guilty, it definitely doesn't seem that way. Thank you for bringing this bill. In addition, I would like to add that I am also in support of unamended AB 160 and Assemblymember Watts. Thank you for being part of bringing this bill. I live in your district and look forward to meeting with you during the session. Thank you.
Thank you for your testimony, Mrs. White. BPS, could we go to the phone line for the next caller, please?
Chair, this is broadcast. We are currently having some technical difficulties. Please bear with us.
Thank you.
Chair, we maybe need 1 to 2 more minutes. We are having an issue getting the PC to connect.
America, I have one in opposition on the Zoom. Do you want me to go ahead and take that testimony and then come back to support?
Chair, that is your call. If you'd like to move forward to opposition, we could do that in the meantime.
Great, thank you. So at this time, I'm going to suspend our support testimony. We'll come back to that in a moment when we get the technical issues figured out. And at this time, I'm going to open it up for opposition testimony. We do have Mr. Cathcart from the city of Henderson with us on the Zoom. So he is not subject to the ongoing technical difficulties at the moment. So we'll give him a chance to provide his opposition testimony. Welcome, Mr. Cathcart, and please go ahead.
Thank you, Mr. Chairman, members of the committee. For the record, Mike Cathcart, C-A-T-H-C-A-R-T. I really appreciate the ability to be on the Zoom today. I appreciate that to be able to present our amendment. I first want to thank Assemblywoman Torres and Vice Chair Wynn for the very positive meeting we had yesterday on this bill. We did have stakeholders together. We had a good conversation about the amendment that we're bringing today and that we're going to need further ongoing discussions. I do want to address Assemblyman O'Neill's question. I'm happy to reach out to some of the other municipalities and find out where they're at on this bill. So it is not just a Henderson amendment. I'll reach out to Las Vegas, North Las Vegas, City of Reno, and see where they're at as far as supporting our amendment. Just from the mechanics of our amendment, it basically adds a subsection 2 to section 1 that would provide an exception for misdemeanors. And I really think the merits of why the amendment was needed have already been discussed. It really has to do with the clock running on possibly a continuance and then the ability to incarcerate someone for a misdemeanor. The limit is 6 months. So, 1 or 2 continuances and you've already run the clock on that. So that's why we would like to see the misdemeanors exempted, but we're also open to having further discussions with the bill sponsor. We committed to that yesterday in the stakeholder meeting. And with that, I'd be happy to answer any questions.
Thank you for your testimony, Mr. Cathcart. I do have a question for you from Assemblywoman Cohen.
Thank you, Chair, and thank you for your presentation, Mr. Cathcart. Can you please tell us, when Henderson decided to propose the amendment and oppose the bill, what was that based on as far as input? Like, for instance, is this just based on the city attorney's ideas, or was there communication with the Muni Court judges in Henderson and the Justice Court judges in Henderson? Like, who's part of that decision making? Or I guess whose input was sought?
Thank you, Assemblywoman. For the record, Mike Cathcart, City of Henderson. The input on the amendment that we're proposing today came from our city attorney's office. It is the exact same amendment that we proposed last session. That comes from the chief of our criminal division. But I believe that our judges are supportive, but I'll have to check on that for you, and I can get you that.
You are in the meeting now.
Okay, thank you for that.
And I will follow up with you today.
Okay, thank you.
Thank you. Let's go to Assemblyman Wheeler for another question.
Hey, thank you, Mr. Cathcart. I'm of kind of two minds on this thing here. I mean, confinement's confinement. We've all seen it during the pandemic, as Assemblywoman Hanson said. But on a misdemeanor charge, I understand what you're saying, that, that maybe the 6 months is already done, or it could even be a year with a 6-month sentence. And if the original bill goes through, it would, negate any type of punishment other than the original confinement. But what I'm wondering is, do you see any civil liability here? And I don't think that, if I remember correctly, I don't think there can be, but I just wanted to put this on the record. Let's just say that someone is confined for a year and then found innocent of all charges. Do you see any civil liability if we put this through, making confinement, that we have confined someone for a year with no guilty plea?
For the record, Mike Cathcart, representing the City of Henderson. From a civil standpoint, I'll have to talk with our civil attorneys on that, but I don't see that. It would be part of the pretrial release program, and I don't believe that we can be held civilly liable for preparing for the trial. But I can follow up with you on that.
Okay, thank you. I think that's the way it is also, but I just wanted to put that on the record so that it doesn't come back and bite us later. Thank you.
We'll go next to Assemblywoman Summers Armstrong for a question.
Thank you, Chair. My question has been answered. Thank you.
Thank you. Any further questions before we let Mr. Cathcart go? Okay, don't see any further questions. Mr. Cathcart, thank you for joining us this morning, for providing your testimony, and for continuing to work with the sponsor on the proposed amendment. We appreciate it.
Thank you, Chairman.
Okay, so now I'm going to suspend opposition and we're going to go back to testimony in support. I think we have our technical difficulties worked out. So if that is the case, BPS, could we go to the next caller in support of Assembly Bill 160?
Thank you, Chair. I do believe that we are back. Would the caller with the last three digits of 037 please slowly state and spell your name for the record and continue with your testimony?
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We do not support the amendment from Henderson City Attorney, the proposed amendment. We do like the bill as written, but would support the Assemblywoman Torres amendment. Thank you and have a good day.
Thank you for your testimony, Ms. Brown. BPS, could we take the next caller in support, please?
Would the caller with the last three digits of 556 slowly state your name and spell your name for the record? You will have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIEGRANT. I'm in support of the bill. I just would like to echo the previous caller's sentiments. I don't support the amendment. I do support the original bill as is. Thank you.
Thank you for your testimony, Ms. Grant. BPS, are there more callers in support?
Yes, there is, Chair. Would the caller with the last three digits of 611 slowly state your name and then spell your name for the record? You will have 2 minutes and may begin.
Good morning, Chairman Yeager and members of the committee. This is John Piro, Johnpiro from the Clark County Public Defender's Office. We support this bill and the amendment. We appreciate the opportunity to be able to argue for credit on a sentence of home confinement before a person is actually sentenced. Often delays in trial or a resolution of a case are out of the control of an individual defendant. Sometimes the state asks for continuances, sometimes our side asks for continuances to discover more evidence. But what we've learned is a lot of the times it's out of a defendant's control, especially even with the COVID-19 pandemic. So providing a credit for a successful stay on house arrest is fair and comports with due process. Thank you, and that concludes my testimony.
Thank you, Mr. Piro. BPS, let's take the next caller in support, please.
With a caller with the last three digits of 695, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair, members of the committee. This is Holly Wellborn, HOLLYWELBORN, Policy Director for the ACLU of Nevada. I will just simply say ditto to the testimony from our colleagues at Nevada Attorneys for Criminal Justice and the Public Defender's Office. We're very pleased to see this legislation before you again and hope we can get it through to the governor's office and are prepared to assist in any way we can. Thank you for bringing this legislation, Assemblywoman Torres.
Thank you for your testimony, Ms. Wellborn. BPS, could we go to the next caller, please?
With the caller with the last three digits of 318, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary. This is Kendra Bertschy, KendraBertschy with the Washoe County Public Defender's Office. We are in support of this bill and the amendments and want to thank Assemblywoman Torres for bringing this important piece of legislation back to this committee's consideration. In respect to Assemblywoman Hansen's question about how this impacts recidivism, there are several studies which indicate that it does significantly improve an offender's ability to be rehabilitated, especially from the U.S. Department of Justice. They had a National Institute of Justice study which indicated that there was a success rate of an increase in 31% compared to offenders placed on the other forms of community supervision. We appreciate, again, all the hard work that has gone into this bill and hope that this will allow people who've had to pay for house arrest, which is an extremely costly device, in order to ensure that they receive the benefit from doing well while on supervision. Thank you so much for allowing me to testify today.
Thank you for your testimony, Ms. Bertschy. BPS, are there any other callers in support?
Yes, Chair, there is. With the caller with the last three digits of 130, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Good morning. My name is Christine Saunders. That's CHRISTINESAUNDERS, and I'm a Policy Director with the Progressive Leadership Alliance in Nevada. I also just want to echo the sentiments of those who spoke before me and add our support for this legislation to the record. Thank you.
Thank you for your testimony, Ms. Saunders. BPS, let's take the next caller, please.
With the caller with the last three digits of 499, please slowly state and then spell your name for the record. You will have 2 minutes and may begin now.
Hello, my name is Jody Hawking. I'm the founder of Return Strong Families United for Justice for the Incarcerated, and my husband's incarcerated at Southern Desert Correctional Center. I actually am in AD 25, and I'm here today representing over 1,000 members comprised of incarcerated people, previously incarcerated people, and family members, friends, and supporters of them.
I want to thank the sponsors and co-sponsors of the bill to have the courage to step up at making Nevada a state that's working towards creating more just communities. The reality is that time served is time served, just as, you know, my other comrades have said, no matter where you serve it, if you serve it in jail or you serve it in the community, giving people good time credit for home confinement is just one way to take a small step towards equity and justice for all of the reasons that have been previously mentioned, and because it really is just the right thing to do. Return Strong is in support of AB 160, and we implore you to continue to look at policy and legislation that offer justice in the criminal justice system. Thank you.
Thank you for your testimony, Ms. Hawking. BPS, do we have other callers in support?
If you'd like to testify in support of Bill AB 160, please press *9 now to take your place in the queue. Chair, there are no more callers in support of Bill 160.
Thank you, BPS. I will close testimony in support. Let's go back to testimony in opposition. Mr. Cathcart, I wanted to ask if you are still there on the Zoom with us. I'm not sure if you're in front of your computer. Looks like you are. Thank you. Thank you for rejoining us. I did have Assemblywoman Summers Armstrong had a question she did want to ask. So if you don't mind, let's go to her for a question.
Thank you, Chair Yeager. Mr. Cathcart, there has been a statement that I'm trying to get some clarity on, and that is the cost of home confinement. So if a person is on a misdemeanor charge and they are on home confinement, can you give me an idea of what the cost is of that confinement pretrial?
Assemblywoman, for the record, Mike Cathcart, representing the city of Henderson. I'll be happy to look into that and get you an answer. I believe that there would be costs in the monitoring of that individual. So we'll need to take a look at that, and I'd be happy to get that answer and get it to the whole committee.
Follow-up question, Chair?
Please go ahead.
Okay, so if I'm understanding this situation properly, there is a cost pretrial for monitoring, and the maximum I've heard today is 18 months maximum for a misdemeanor. If a person is then convicted of the misdemeanor and they're given 6 months, not only would they have additional confinement, but they also have, if they're not in municipal jail, if they're back on home confinement, they have to continue to pay that cost for the additional 6 months.
Thank you, Assemblywoman. For the record, Mike Cathcart, representing the city of Henderson. The maximum sentence that can be levied on a misdemeanor is 6 months. I believe if it was 18 months, it would be a completely different conversation. The reason we are bringing the amendment is because of the 6 month sentence limitation under misdemeanors. But following up on the last bit of your question about the cost, I'm happy to, like I said, get that information. I don't have that at my fingertips on what it costs us to monitor someone on home confinement. But just want to clarify that we are limited to 6 months on a misdemeanor offense.
Chair, just one more question, if that's okay.
Please go ahead.
Clarity. Thank you, sir. Mr. Cathcart, can you just explain why it is important for the city of Henderson to have the option to not be able to apply any credit for home confinement? That part, I saw your amendment, but I just don't understand what the opposition is. Maybe I missed it in the conversation.
Thank you, Assemblywoman. For the record, Mike Cathcart, representing the city of Henderson. I believe what we're looking at is if the time has run on the misdemeanor charge and we're not able to impose any sort of sentence or a suspended sentence, we don't have the ability to make sure that the sentence is carried out. I mean, it could be anger management classes, it could be DUI classes, it could be a lot of other things. We need a mechanism to make sure that those things happen after the trial. And if entire sentence is already run on the confinement option, we would not have a way to make sure that those post-trial sentence requirements are followed through on.
And Vice Chair Wynn, did you want to add something on that question as well from your perspective in the field?
Yeah, I can tell you the house arrest, just so people are aware, house arrest can cost anywhere between, I've seen as low as $8 and up to $20 a day on house arrest. I will tell you that certain jurisdictions have different requirements. Like, for example, the Clark County Detention Center, their pretrial division, inmates are not, or in people that are incarcerated that are put on pretrial house arrest, they actually do not have to pay for the house arrest. So it is included. A lot of other jurisdictions, those costs do go on the defendant pretrial to pay for those. So there's just a lot of varying degrees on whether or not and who incurs those costs. I think some jurisdictions realize that they're saving putting people on house arrest and by not incarcerating them in their detention facilities, and some people don't have the mechanisms yet to have that, and so the costs do go on the particular defendant.
Okay, we'll go Assemblywoman Kasama. Did you have a question for Mr. Cathcart?
I do.
Please go ahead.
So Assemblywoman Heidi Kasama, District 2, Mr. Cathcart. Your last response, if the judge still had the ability to, for example, mandate anger management classes or drug help or training or classes, would that alleviate the concern so that the time spent on house arrest would still cover the sentence, but if the judge had leeway to impose additional counseling or treatment, would that make it work for you, the allowing the house service for the misdemeanor?
Thank you, Assemblywoman. For the record, Mike Cathcart, representing the city of Henderson. I think the problem there is if the entire 6 months is the clock is run through a continuance or 2 continuances to the trial, and they're giving credit for the entire 6 months, there would be no mechanism to make sure that they, even if the anger management classes or the whatever mitigation classes are ordered by the judge and the rest of the sentence is suspended, there was no way for us to, there's no hammer basically to make sure that they go and they take those anger management classes and that they do their DUI school and those types of things. We got to make sure that there is some sort of punishment mechanism to make sure that they go to those classes.
I understand that if so that makes sense. And so if you had a punishment mechanism, for example, that they would have to return to jail then if they didn't follow those, would that be enough of a hammer? And is that something we could perhaps look at?
I thank you, Assemblywoman. For the record, Mike Cathcart, representing the city of Henderson. I think we're kind of on the same page. We under statute, we still have to have some time. We're limited under NRS to 6 months. And if that 6 months is already run under residential confinement, we are unable to levy any other confinement after that. We're limited at the 6 months. I think that's our concern.
Mm-hmm. Maybe this is an opportunity, since we're presenting the bill, to add in the hammer, as you say, that they could go back for incarceration if they don't fulfill classes that are ordered by the judge. Just a thought. Thank you so much for your information and insight.
Chair, if I could just respond to that. I appreciate Assemblywoman Kasama's question on that. And I think this bill actually does that because it is discretionary for the judge to give credit. So if people are, they want to be able to have some additional leverage for people to complete any requirements of their ultimate sentence, it would be up to the judge to determine if they wanted to give credit or partial credit for that time spent on residential confinement.
Thank you.
Thank you, Mr. Cathcart, for rejoining us. I know it's been a little bit sporadic this morning in terms of participation, but we appreciate you being on.
Thank you, Mr. Chair.
Okay, so we are still on opposition testimony. We don't have anyone else on the Zoom. BPS, could we check the phone line to see if there's anyone there who'd like to offer opposition testimony on AB 160?
To testify in opposition of Bill 160, press star 9 now to take your place in the queue. Would the caller with the last 3 digits of 389 please slowly state and then spell your name for the record? You will have 2 minutes and may begin.
Thank you. My name is Jennifer Noble, Jennifer Noble. I am a Chief Deputy District Attorney in the Washoe County District Attorney's Office, and I am testifying in opposition on behalf of my office and the Nevada District Attorneys Association. Before I get to my testimony, I want to thank sincerely Assemblywoman Torres and Vice Chair Wynn for meeting with us about our concerns. And we do appreciate the intent behind this bill, but we are in opposition today. A day on house arrest is just simply not the equivalent of a day in a detention center. The credit for time served needs to reflect that. If you have 2 defendants who've got similar backgrounds, who committed similar offenses, one remains in the detention center for one reason or another, and the other makes pretrial release with house arrest as a condition, maybe because they can afford it in their particular jurisdiction. One person is going to be earning that credit in jail, and the other is going to be earning that credit in their residence. If they're sentenced to similar sentences, one of them is going to spend a lot more time confined behind bars. This is not equitable. People in house arrest are not just shut inside their residences with no ability to leave. Yeah, they're monitored. It's a restriction of their liberty. But I disagree with the representation of earlier callers that time served is time served. And I'm sure everyone on this committee can imagine, whether you're a parent or not, that the ability just to see your child, hug your child, sleep in your own bed, wear your own clothes, choose what you eat for dinner. You can step into your yard when you want to. These are big differences in terms of what people on house arrest experience versus people who are confined behind bars in an institution. In many ways, it's arguably closer to the conditions we've experienced over the last year than it is to somebody who's locked inside a detention facility with other people, and they might be dangerous, they might be not dangerous, sharing rooms with people, sharing toilets with people, not necessarily having a door when you go to the bathroom. These are big differences between house arrest and residential and incarceration. So that has to be reflected in the credits awarded. It's not equitable. And it does play a factor at sentencing. When people are sentenced to house arrest, their defense counsel can argue about their participation in house arrest as a mitigating factor. The judge might give them a lighter sentence on the back end because a defendant has participated in house arrest and done so without any violations. Additionally, this makes our already confusing prison credit scheme more confusing. I know many of you follow the Advisory Commission on the Administration of Justice, and Justice Hardesty has commented, and other members, on numerous occasions on how confusing our credit scheme is. Victims don't get it. Quite frankly, prosecutors often don't understand it. So just using house arrest credits to reduce somebody's time in prison, in our opinion, adds to a confusing scheme for victims. And it's for those reasons, Mr. Chairman and members of the committee, that we are in opposition here today. But we remain committed to working with the sponsors to see if we can come to some sort of common ground on this bill. Thank you.
Thank you for your testimony, Ms. Noble. BPS, are there other callers in opposition?
Chair, there are no more callers in opposition at this time.
Thank you, BPS. I'll close opposition testimony. Let's go to neutral testimony. This doesn't seem like a bill where we're going to have neutral testimony, but let's check anyway. I don't see anyone on the Zoom. BPS, is there anyone on the phone who'd like to offer neutral testimony?
To testify in the neutral position on Bill 160, press star 9 now to take your place in the queue. Chair, there are no callers in the neutral position on Bill 160.
Thank you, BPS. That was as I suspected. A bill like this doesn't often get neutral testimony, so we'll go ahead and close neutral testimony on the bill. I'd like to turn it back over now to Assemblywoman Torres and Vice Chair Wynn to make any concluding remarks on Assembly Bill 160.
Thank you, Chair, and thank you, committee, for indulging us in the presentation today. I do appreciate it. I just want to iterate that, currently we do get credit for house arrest post-sentencing, and really it just makes sense that we do this for pretrial residential confinement as well. As my colleague Assemblyman Wheeler said, confinement is confinement. And I think that we recognize that in a new way. And while during the quarantine period in early 2020, many of us might have felt that we were as confined, but rather the restrictions on individuals that are in house arrest are even more confined. They cannot go for a walk. Like I would indulge in a walk very early on. They don't have the privilege of being able to indulge themselves in some of the very basic things that we appreciate in our everyday life. And so confinement is confinement. I look forward to continuing to work with our stakeholders to pass a strong piece of legislation that will protect the liberties of our community.
Thank you. Vice Chair Wynn, would you like to make any concluding remarks?
No, I'll wait, but I am available if anyone has any questions offline regarding how the process actually works in practice. And I look forward to having those continued conversations with not only the District Attorneys Association, but as well as the City of Henderson and the other municipal jurisdictions.
Thank you both for presenting the bill. Assemblywoman Torres, if you could just keep me updated on progress in terms of further amendments on the bill, I would appreciate it. Thank you for joining us here. It's good to see you again in the Assembly Judiciary Committee. And I suppose you are now released to head back to Assembly Government Affairs.
Thank you, Chair.
Take care. So I'm going to close the hearing on Assembly Bill 160. We're now going to go to our first bill listed on the agenda, and I will open the hearing on Assembly Bill 145. We're going to be shifting gears with this one. Assembly Bill 145 adopts the Uniform Registration of Canadian Money Judgment Acts. So we went from criminal law and incarceration to civil law and money judgment, which is going to make for a good discussion, I believe. So we have our own Assemblywoman Cohen to present the bill, and she has some presenters with her. And I want to welcome back to the committee our former colleague, former Assemblywoman Shay Backus. It's good to have you back in the Judiciary Committee and see you, if only virtually. And then I believe we also have Ms. Wolf and Mr. Kaplan. So thank you all for your patience in sitting through that first bill hearing this morning. Assemblywoman Cohen, when you're ready to kick things off, please go ahead.
Thank you, Chair. Chair Yeager, Vice Chair Wynn, and committee, I'm Leslie Cohen, representing Assembly District 29, which is mostly in Henderson and a little unincorporated Clark County. I'm honored to present AB 145, the Uniform Registration of Canadian Money Judgments Act. The Uniform Registration of Canadian Money Judgments Act was drafted by the Uniform Law Commission, also known as the National Conference of Commissioners on Uniform State Laws, which is an organization comprised of volunteer attorney commissioners appointed by the 50 states and the United States territories and the District of Columbia. Since 1892, the Uniform Law Commission has drafted nonpartisan legislation in areas of state statutory law where uniformity is necessary and beneficial. Nevada has a long history of enacting uniform acts. In fact, Nevada's enacted over 100 uniform acts, such as the Uniform Commercial Code, the Uniform Child Custody Jurisdiction and Enforcement Act, the Uniform Transfers to Minors Act, the Uniform Anatomical Gifts Act, and the Uniform Deployed Parents Custody and Visitation Act. The Nevada legislature passes these acts because they're good law for our citizenry. Uniform Law Commission members must be lawyers qualified to practice law, and uniform law commissioners are practicing lawyers, judges, legislators, and legislative staff and law professors. Like several other current and former Nevada legislators and LCB staff attorneys, I'm a uniform law commissioner, having been appointed after my first term in the legislature. Before I introduce my fellow presenters and we get into the bill, I'm just going to give you a little taste of what it's like to serve on the drafting committee with the ULC. I currently serve on the Uniform Parentage Law Redrafting Committee, which was started in 2017. And along with commissioners, top practitioners in the field, law professors, judges, and stakeholders, we all meet in person and telephonically several times to work to draft the best law possible. And it's basically going line by line in the proposed law. The law is also vetted by a separate style committee, and along the way, the full commission consisting of commissioners from all 50 states, the District of Columbia, and territories has the opportunity to debate the act. Please note that the ULC can only propose and advocate for acts. No uniform law is effective until it is adopted by state legislatures. Presenting with me today is Nevada Uniform Law Commissioner Shay Bacchus, Caitlin Wolf, Uniform Law Commissioner, Legislative Counsel, and Kirk Kaplan, who is a Nevada attorney and CPA and a member of the Canada-Nevada Business Alliance. I'll now turn the presentation over to Commissioner Bacchus. And Chair, I just want you to know, because you're often concerned about CLEs and we should get CLEs, but we don't get CLEs. Just so you know, Nevada does give CLE credit for attending the yearly Uniform Law Commission Conference and working on the drafting committees. So with that, again, I'll turn it over to Commissioner Bacchus.
Good morning, Chair Yeager, Vice Chair Nguyen, and members of the Committee on Judiciary. For the record, I'm Shay Bacchus. I'm here in my capacity as a commissioner for Nevada on the National Conference of Commissioners on Uniform State Laws, often referred to as the Uniform Law Commission. Today, it is my pleasure to introduce Assembly Bill 145 with Assemblywoman Cohen, who is also a ULC commissioner. I want to first take a moment to thank Assemblywoman Cohen for sponsoring this Uniform Act. The Uniform Registration of Canadian Money Judgment Act is designed to work alongside with the Uniform Foreign Country Money Judgment Recognition Act, which Nevada adopted in 2007. This Recognition Act is now codified in Chapter 17 of the Nevada Revised Statutes. With the enactment of the Uniform Registration of Canadian Money Judgment Act, a Canadian judgment, once registered pursuant to the Act, may be enforced in the same way as a judgment rendered in this state. There are several advantages to enacting this Registration Act. First, it streamlines the recognition and enforcement process of a Canadian money judgment. Under the current Uniform Foreign Country Money Judgment Recognition Act, a person who has received a foreign judgment has to file a lawsuit in order to have their foreign judgment recognized. The Registration Act offers an expedited administrative process to accomplish the same goal. This ultimately reduces legal costs associated with enforcing the foreign judgment. Second, the process established in the Registration Act was designed to reduce judicial workload and help decongest court dockets because it does not require the court to hold a full judicial proceeding to recognize and enforce a Canadian money judgment. Third, this Registration Act establishes a registration procedure similar to the Canadian registration procedure regarding foreign judgments, including a judgment secured in Nevada. This similar registration procedure will benefit those registering judgments from Canada and Nevada under this Act, and those registering Nevadan judgments in Canada under the Canadian statutes. Most importantly, the enactment of this Act will facilitate commerce between Nevada and Canada. Canada is one of the United States' most important trading partners. The Registration Act facilitates commerce between the two countries by offering a streamlined, less expensive procedure for the recognition and enforcement of money judgments, which are a result of commercial activity between the nations. According to the Business Council of Canada and Nevada, a nonprofit, Canada is Nevada's third largest export market, and prior to COVID-19, 82,800 Nevada jobs depended on trade and investment with Canada. Thus, streamlining recognition and enforcement of Canadian money judgments in Nevada will continue to facilitate commerce between Canada and Nevada. The timing of this hearing is quite interesting, as it was about 2 years ago that there was Canada Day at the legislature. I understand for those freshman legislators now serving in judiciary, with the building closed, you don't get to see it, but Canada Day is where there were events throughout the day and a reception in the evening. And so it exemplifies the relationship between Nevada and Canada. At this time, I will turn this presentation of AB 145 over to Caitlin Wolf, who is Legislative Counsel for the Uniform Law Commission, and she will walk you through the sections of the proposed bill.
Hi, good morning. Members of the committee, Chair Yeager, Vice Chair Wen. It's a pleasure to be with everybody this morning. Assemblywoman Cohen, thank you for inviting me to be part of your presentation. Assemblywoman Cohen has asked me to walk the committee through the bill section by section to give you a sense of how it works. So I'm going to go ahead and do that. It's a rather short bill, so I don't expect this to take too long. Just to dive right in, sections 1 through 5 are sort of the general introductory matter. So establishing where this Uniform Act would be situated within the Nevada statutes, establishing the title of the act, and setting forth a couple of definitions you'll see throughout the bill. Section 6 of the bill is where the substance of the act really starts to come into play. This section explains that this particular Uniform Act applies to a Canadian money judgment that falls within the scope of the Recognition Act. As Commissioner Backus already explained, the Recognition Act is a Uniform Act that Nevada has already had on the books for several years at this point. And the Uniform Act that you're considering today is a supplement to that act and is an alternative. So Section 6 explains just how these two uniform acts work together. Section 7 is really the meat of the act. So again, the whole purpose of AB 145 is it establishes a simple, streamlined administrative procedure for how to register and get enforced a Canadian money judgment in Nevada. So Section 7 explains what paperwork, what documents need to be submitted to the clerk of court in Nevada in order to jumpstart that process. So subsection 2 of section 7 explains exactly the information that needs to be transmitted to the clerk of court. And then subsection 3 explains what happens. What does the clerk of court do once he or she receives all of the documentation, information, and registration fee? Well, at that point, the clerk needs to file the registration, assign a docket number, and enter the Canadian judgment on the court's docket. Subsection 4 of section 7 provides a sample form that could be used during this registration process. So it contains all of the information and that is also listed in subsection 2 of the bill, just in a form format. And part 5, the last part of that sample form, also contains a handy checklist of attachments and documentation that would need to be transmitted to the court along with the standard paperwork. So for instance, a copy of that Canadian judgment, a translation of it, if that happens to be in French or another language other than English. But that's section 7. So section 7 is a huge portion of the bill here, laying out what documentation is needed. Section 8 explains, well, what comes next? So once the registration paperwork has been transmitted to the Nevada court, once the clerk has entered the Canadian judgment on the court's docket, section 8 explains that that Canadian money judgment is enforceable in the same manner and to the same extent as a judgment that's rendered in Nevada. It's treated exactly the same. So the enforcement procedure is just the same as a Nevada enforcement procedure would be. One important thing to note here in section 8 is there is a grace period. So you can't just seek registration, have it put on the court's docket, and then go ahead and enforce and collect that money. There is a period of time, a 30-day period to pause because notice, of course, needs to be provided to the party against whom this judgment is entered. And that's where the next section of the bill, section 9, comes into play. It's all about notice, and the notice must be served on the person against whom the judgment has been registered. This section establishes what must be in the notice. And this notice also makes it clear to the person that he or she has an opportunity to petition the court to vacate the registration. They have a 30-day period in which they can do that. They can petition the court. Section 10 establishes what grounds must exist in order to petition the court to vacate. So if they want to get this registration thrown out, they may either argue, one, that there's a ground for denial under the Recognition Act. So again, you're already existing uniform law in Nevada pertaining to these foreign country judgments. There's a list of grounds under your existing statute. So if one of those grounds exists, or the person can argue to vacate the judgment because the registration procedure was not followed properly. Perhaps an attachment didn't get to the court, perhaps the paperwork was missing or not filled out properly. That would also be a ground. Section 11 of the bill then explains, it goes hand in hand with Section 10. If an individual does choose to petition the court to vacate, they can also ask the court to stay enforcement of the judgment while they're waiting to hear back for the court's determination of that petition. So a stay meaning pause, don't try to collect on the judgment, don't go after my assets, don't try to collect because I think there's a problem with this underlying Canadian judgment. Section 12 of the Act explains in a little bit more detail how this registration procedure integrates with the Recognition Act that we've already mentioned a couple of times. So essentially, it lays out that if somebody wants to recognize and enforce a Canadian money judgment in Nevada, they have two options. They have either this new registration procedure under AB 145, or they're also welcome to use the existing procedure under current law, which would be, as Commissioner Backus stated, filing a lawsuit and doing a little bit more of an extensive procedure. That's still an option. This section of the bill makes it clear that you cannot pursue both options at the same time. You either are going to seek registration through this act or go through the previous existing law procedure. And then sections 13 and 14 are pretty standard. One is our uniformity language. That's a part of all of our uniform acts in section 13. And section 14 contains the effective date of the bill. And that is a quick run through of the bill. So at this time, I will turn it over to Kirk Kaplan, who I believe will give a couple of comments next.
Good morning, everyone. Thank you, committee members, for allowing me to say a few words to this committee in support of AB 145. Briefly, I help Canadians with structuring their investments, including businesses in Nevada. I help them plan for positive tax results between Canada and the United States for income tax purposes, and help them avoid and lessen court involvement during their incapacity and after death. AB 145 is another one of those acts that will help Canadians reduce court involvement here in Nevada and thus implement or help our trade with Canada. Bill AB 145 now before this committee is nothing new regarding uniform acts, as Assemblywoman Cohen and Commissioner Backus explained. Another such uniform act regards international matters. Nevada already has an international laws in its NRS, Chapter 133A, which is the International Wills Act, where we can domesticate Canadian last wills and testaments to be accepted in Nevada. And we don't have a lot of litigation whether they were properly executed in the province or territories. As such, AB 145 is just one of many natural progressions Nevada should recognize as we broaden our trade with Canada. I'm sure you know Canada is one of the United States' most important trading partners in the world. Just to quote James George, a professor of law at Texas A&M University, in his law review in November of 2020, discussing the uniform law AB 145 now is, he wrote, vibrant economies benefit from predictable and consistent judgment enforcement regimes. Canada has many shared Western values with the United States, including similar due process requirements and other legal and judicial matters. I know this. I've been involved in a few litigation matters, not personally, but helped other people in Canada. While I'm not licensed there, I have been involved in some litigation matters, and I know that their judicial process up there is similar to ours. It's a bit different, but similar. Allowing Canadian judgments to be entered into Nevada does not strain Nevada concepts of due process, and as such is wise to allow AB 145 to be entered into the laws of Nevada. Thank you for letting me speak.
Thank you so much to the four of you for the presentation. And before I ask a couple questions, I did want to note Senator Orenshaw is a joint sponsor of this bill. And he, for those of you who don't know, he was a member of this committee for 6 sessions and now is serving his 2nd session on the Senate Judiciary Committee. And I just mentioned that because he is a big fan of uniform law bills. And I remember when I was a freshman, he probably tried to shop like 20 of them to me to get me to sponsor them. And I think I did one. But as he liked to say, and Assemblywoman Cohen reminded me of this, he would sometimes say that these bills may not be the most exciting bills you've ever seen, but he liked to reminisce about the time that a fist fight broke out between uniform law commissioners during a conference as they fought over language in a proposed act. So I think by the time the bill gets to us, it's pretty well ironed out, but there is some debate and arguing that happens at the convention level. So, thank you to the four of you for your service in making this happen. I'm sure I'm going to have some questions from others, but I wanted to ask just a couple. And Assemblywoman Cohen, you might have mentioned this in your introduction. If so, I just missed it. But I wondered where we're at in terms of other states adopting this uniform law. If you could give me a sense of how many states have adopted it or might be planning to do so in the very near future.
Thank you, Chair. Leslie Cohen, Assembly District 29. I did look it up. It's relatively new, so it hasn't gone through a lot of states yet. I believe there are 2 states that have adopted it so far. So, and then I should also note the thing with the uniform law is there are some things like UCC where every state basically adopts it. And then there are other things that it just kind of make their way through the different states and do get adopted or don't get adopted and aren't as universal as UCC or the UCCJEA, having to do with jurisdiction in custody, child custody matters. And then if Ms. Wolf, if I'm incorrect about the 2 states, if you want to correct me on that.
Yeah, Caitlin Wolf here from the Uniform Law Commission. Just to jump in really quickly. So you're right, it's been adopted in Colorado so far. It's also pending in a couple of other jurisdictions this legislative session. So in addition to your Nevada bill, it's also pending in Nebraska and Rhode Island. The bill was finalized at the end of 2019. So unfortunately with COVID and, being everything occurring over the last year, it's had a little bit of a slower start. But what's nice about your situation in Nevada is you already have that underlying supplemental bill, the Recognition Act, on the books already. I'm actually working with several states to get that on the books now, including New York and a few others, before they can adopt this piece. So you guys are one step ahead, but a slower start for this bill, but we have a couple of other jurisdictions considering it now.
Thank you. Ms. Backus, I saw that you had your hand up. Did you want to add something on that point as well?
Shay Backus for the record, Chair Yeager. No, I just was going to fill in the blanks on that. So thank you to Caitlin Wolf for that.
Great, thank you. And then, I think I know the answer to this question, but I want to ask it just for edification of the committee because I suspect some of you may be on Judiciary for several sessions to come, and this certainly won't be the last uniform law bill that we hear. So, my question is sometimes we get these bills and then people on the committee want to amend them in some fashion. But my recollection was that there is some need for uniformity among the states for these to be effective, essentially. And so if you could just speak to that, not that anyone's trying to propose an amendment to this one, but if you could someone could speak globally about sort of that issue and the need for uniformity among the states.
Ms. Wolf, I can answer, but if you'd like to answer, please go ahead.
Go ahead, Assemblywoman, please.
Okay. Right. Well, the idea is that there are certain things that should be uniform between the states because it makes it easier to do business and to know what you're going to deal with from state to state. And then as far as changes that can be made, there's kind of like a line, right? That you can individual states can make changes up to a point, and if they cross the line, then it's no longer considered uniform law. So it just depends. You know, I know there's another uniform law piece that I'm bringing. Hopefully, the language will be out soon. And there's a whole section that I want to remove because I don't like it. I know that when similar things had been before this committee in different sessions, the committee didn't like it. Frankly, the speaker doesn't like it. But I know that even if that section is removed, the ULC has determined that it would still be uniform law. So does that cover it?
It does, thank you. And it just I guess a word of advice for committee members. If you see these kind of bills in the future and you're interested in amending them in some fashion, please check with the sponsor because they have to go back to the Uniform Law Commission to make sure those amendments aren't going to essentially invalidate the uniform law being adopted in some sense. So they're a little more complicated than some of the bills we consider in that regard. And so hopefully that will help any of you in your legislative service this session and beyond. I don't have further questions on the bill, but do we have committee members who have questions on Assembly Bill 145? We'll start with Assemblywoman Kasama.
Mine is a simple question, just understanding in section 10 and 11, you talked about where there's a 30-day notice so that the person that has the judgment served against them can respond. And in section 11, it gives them an opportunity to, I guess, contest it. I guess my question just is, if a person here in the US, after they've been served this judgment, says, no, I don't think it's right. So then would it go back to the Canadian court for resolution? I'm just curious how it works.
I'm happy to answer the question unless Commissioner Bacchus, would you like to jump in?
Yeah, no, I would be happy to. Thank you, Ms. Wolf, and feel free to add on. So Shay Bacchus, for the record, through Chair Yeager to Assemblywoman Kasama. Basically, what would happen is there is a procedure. They would petition the court here where the judgment had been registered to challenge it. And so under the act before you, there's limited provisions of what could be challenged. And so if there was like a substantive challenge, you can look also under the Recognition Act, which details numerous reasons. So that would be fleshed through here in our courts. But one of the things that could happen is, let's say that the Canadian judgment was subject to appeal and it wasn't a final judgment. In that situation, the court here, someone would petition, explain that it's pending an appeal, and obviously the appeal would finish out. But if there were other substantive challenges to the underlying matter, that obviously has to be brought in that court. But just with respect to whether or not it could be enforced, that would be subject to our district courts here. And I don't know if Ms. Wolf would like to add anything else to that.
No, I think that covered it. Thank you.
That explains it well. Thank you so much.
Do we have other questions from committee members? Assemblyman O'Neill.
Thank you, Chair. Quick question. Does Canada have a reciprocity or a recognition of Nevada? If we're doing it for them, are they doing it for us?
I'm happy to answer that. Shay Bacchus, for the record, through Chair Yeager to Assemblyman O'Neill. Basically, I looked this up because I like the terminology reciprocity, and usually with reciprocity, it's like if it's good for one state, it comes back to the other. It's an even balance. In this situation, Canada already has statutes on their books in certain different provinces and territories. So like we're before Nevada seeking to get this uniform law passed, different territories in Canada likewise would have that statute. So it's not necessarily reciprocity, but there are already laws on the books that contemplate recognition and registration of judgments from the US, including a state like Nevada.
If I may, Chair.
Please.
Just for clarification, Ms. Backus, you're saying they're considering it. So they don't have the law now, if I understood you correctly.
Shay Backus, for the record, through Chair Yeager to Assemblyman O'Neill. No, that's not what I'm saying. There are already statutes in place in Canada, just depending on the territory and province, like we have in the United States, considering various laws. They do already have statutes. I just don't want to say every territory and province in Canada has it on the books, but some do. And we also had there's a Uniform Law Commission of Canada where individuals also sat from that commission on or were like visitors or participants in the Uniform Law Commission also implementing this uniform law.
Thank you. Thank you, Chair, for the time.
You're welcome. Other questions from committee members? Assemblyman Ornlicker.
Thank you, Mr. Chair. And for this, I'm not sure whoever wants to answer this. I'd be helpful just to hear like a typical example of a judgment that would benefit from this and how this act would change from where we are, with one or two illustrative examples.
Ms. Backus, do you want to take that?
I'm happy to do that. Shay Backus, for the record, through Chair Yeager to Assemblyman Ornlichter. So what could happen is someone files a lawsuit in Canada. So let's just say there's a breach of contract and the Canada courts are the right. Let's say Toronto or another city where someone files a lawsuit over a breach of contract where there's proper personal and subject matter jurisdiction in Toronto between the two parties. The plaintiff becomes the prevailing party to that breach of contract action, where the key is there has to be a money judgment of sorts. So it couldn't be anything else like where you're mandating performance under the contract. It would have to be for a money judgment. So they recover, let's say, $100,000. The plaintiff realizes the defendant has no assets or limited assets to satisfy that judgment in Canada. The time for appeal is exhausted, and that judgment in Canada becomes a final judgment in favor of the plaintiff for, let's say, the $100,000. The plaintiff realizes the defendant has assets or has a business in Nevada. They would take that $100,000 judgment and they would register it here in our, let's say, district courts at the defendant's businesses in Clark County to make it easier if they were going to do like a writ of attachment of sorts. So they would come to Nevada, they would record, they would file the form is already provided. They could hire a counsel or they could do it themselves if they're an individual and not a corporation. They would register that judgment here in the 8th Judicial District Court. Once it's registered, they then give notice pursuant to the act to the defendant, and they wait the allotted time. If there is no challenge, then that is now a registered judgment here, and they could simply take that registered judgment, seek a writ of attachment of assets here in Clark County. Hopefully that answers your question. I'm happy to elaborate.
Okay, no, that's very helpful. Does this happen very often?
Shay Backus, for the record, through Chair Yeager to Assemblyman Orlichter. I've seen it. I actually was in a hearing before Honorable Crockett, and we don't have the Registration Act, but under the Recognition Act, where someone actually has to petition and have a hearing. I sat through one and I thought that was kind of interesting. I had never seen it before. And yeah, that's the only time I've seen it. It's not common in my practice, but I don't do too much international practice, although I do civil litigation.
And now I really think we should be getting continuing legal education for the attorneys on this committee or anybody watching. This is some pretty good stuff in terms of how the civil justice system works. Other questions from committee members before we move on to testimony? Doesn't look like we have other questions. So for now, I want to thank the four of you for presenting. I'll ask you to sit tight for a moment. We'll see if there's any testimony on the bill, and then we'll come back for any wrap-up testimony that any of you may have. So at this time, I'll go to testimony in support of Assembly Bill 145. We don't have anyone with us on the Zoom in support. BPS, could we check the phone line to see if there's anybody there who'd like to testify in support?
To testify in support of Bill AB 145, press star 9 now to take your place in the queue. Chair, at this time, there are no callers in support of Bill AB 145.
Thank you, BPS. I will close testimony in support. I will now open it up for testimony in opposition. We don't have anyone with us on the Zoom in opposition. BPS, could we check the phone line to see if there's somebody there in opposition?
To testify in opposition of Bill AB 145, press star 9 now to take your place in the queue. Chair, there are no callers to testify in opposition to Bill 145.
Thank you, BPS. I'll close opposition testimony. I will now open neutral testimony. We don't have anyone with us on the Zoom in neutral. BPS, could you please check the phone line to see if there's anybody there in the neutral position?
To provide neutral testimony on Bill AB 145, press star 9 now to take your place in the queue. Chair, there are no callers who want to provide testimony in the neutral position on Bill AB 145.
Thank you so much, BPS. So I will close neutral testimony. We didn't have any testimony on the bill, but Assemblywoman Cohen and everyone else want to give you a chance to make any concluding remarks. So Assemblywoman Cohen, please go ahead.
Thank you, Chair, and thank you to my fellow presenters. I appreciate your efforts in working toward getting this legislation passed. With that, I'll just leave it with I'm available if anyone has any more questions about the Uniform Law Commission or this legislation in particular, and invite the other presenters to make any final comments they'd like.
Great, thank you. So let's just go in the same order as the presentation. So Ms. Backus, would you like to say anything in closing?
Just thank you to Chair Yeager, Vice Chair Nguyen, and the Judiciary Committee for considering this bill to move Nevada forward with respect to commerce and other good aspects, especially coming off of COVID-19. And just thank you for your time and your service today.
Thank you, Ms. Backus. It's good to see you again in the Assembly Judiciary Committee. Ms. Wolf, any concluding remarks?
Just would like to echo my thank you to you, Chair, to Vice Chair Nguyen, and members of the committee. Thank you for your time, and I do hope that we'll earn your support for this bill. As Commissioner Backus just mentioned, I think in particular coming after this pandemic, as it comes to a close, as courts are looking at overburdened dockets, it's in particular a good time to be thinking about this bill. How can we lighten their load? How can we streamline the process while still providing due process to all parties involved in these sorts of judgments? So again, thank you very much for your time.
Thank you, appreciate it. Mr. Kaplan, any final remarks?
No, but thank you very much for allowing me to speak on behalf of this bill. I think it will be a great benefit to Nevada and its trade with Canada.
Thank you, and thank you again to the four of you for presenting this bill this morning. We appreciate it and hope you have a great rest of the day and a great rest of the week. With that behind us, I'll close Assembly Bill 145. That takes us to our last item on the agenda this morning, which is public comment. By way of reminder, we'll reserve up to 30 minutes for public comment. It'll be at the end of each meeting, and callers in the public comment line will have up to 2 minutes to provide public comment. I think we may have a few public commenters today. BPS, could we go to the phones and confirm that there's somebody there? And if so, could we ask the first public commenter to provide testimony?
To provide public comment, please press *9 now to take your place in the queue. With a caller with the last 3 digits of 037, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Tanya Brown, TONJABROWN, advocates for the inmates and the innocent. Good morning, Chair and members of the Judiciary Committee. I would like to say thank you to Assemblywoman Torres for bringing AB 160 forward. And I would also like to thank the committee for Friday's work session. I was right in the middle of something that got my attention, needed my immediate attention, and I'm sorry I couldn't respond. But thank you very much for passing the legislation out of committee, the bills out of committee on Friday. Excuse me. Thank you and have a good day. Bye-bye.
My goodness.
Thank you for your public comment, Ms. Brown. BPS, is there anybody else for public comment?
With a caller with the last 3 digits of 556, please slowly state and then spell your name for the record. You will have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE, Sister of Thomas Purdy, who was 38 years old when he was hogtied by Reno police during a mental health crisis and asphyxiated to death by Washoe County deputies while still hogtied. Today I want to talk about 36-year-old Nicholas Farah, who died at the Clark County Detention Center on March 31st, 2019. Nick's story reminds me a lot of my brother Thomas. Nick was arrested. Nick was actually passing through Las Vegas. He was on his way home from a vacation in California at Disneyland with his family and 2 daughters. He had a layover in Las Vegas. He ended up getting robbed. His backpack was stolen. He just wanted to report it. Las Vegas Metro showed up, arrested him, I guess, for trespassing, which was the charge my brother was killed over as well. When they got Nick to the Clark County Detention Center, they put him in a restraint chair. And I bring this up because I want the members of the board to realize that these devices that are being passed off as safe, they are not safe. All you have to do is research it. Many, many, many people die in these types of devices. They put Nick in the chair. It's all on video. Nick wasn't even combative with them, didn't try to assault anybody. And they put Nick in the restrained chair, his arms over his head, and pushed his head down in between his legs, and asphyxiated him to death. The medical examiner ruled his death a homicide, just like my brother Thomas Purdy. Please do not support bills that promote and protect bad police officers. Please support bills that promote transparency and accountability. Our families, my family, and so many other families are counting on you. Thank you.
Thank you for your public testimony, Ms. Grant. Could we go to the next caller, BPS?
Chair, the public line is open and working, and there are no more callers at this time.
Thank you, BPS, and thank you for helping us work through some of those technical difficulties we had today. As always, we appreciate the work that you're doing for the committee. I will close public comment. Before we talk about the rest of the week, anything else from committee members this morning? Okay, I don't see anything. I wanted to say that I missed you all yesterday. It felt very strange to not have a Judiciary Committee meeting in the morning. So I'm glad that we're back together this morning and want to thank all of you for your attention and good questions this morning. In terms of the rest of the week, we do have Judiciary Committee meetings scheduled every day the rest of the week. We will be starting at 8 o'clock. I'm pretty excited about what we're going to be hearing. Tomorrow we have cannabis, alcohol, and civil actions on tap. On Thursday, we're going to hear an evictions bill. So I'm sure that one will generate some interest. And then on Friday, we're going to hear bills relating to paternity and prostitution. So we can put those two together on the same day. That's what we've got so far. We're still looking at building next week's agenda, but that's where we are for now. So with nothing else in front of the committee this morning, I will see you all at 8 o'clock tomorrow. And we'll also remind members that we do have floor today at 11:30. So please try to be down there promptly. And with that being said, I'll see you tomorrow morning at 8 o'clock. This meeting is adjourned.